Expropriation without compensation is still very much on the agenda. During the past holidays, a bill was published containing the text on how the ruling party and, of course, its alliance partners in this struggle intend on changing the text of the Constitution to empower the state to expropriate private property without compensation. There's also a variety of legal issues with regard not only to that bill which has been published, but also other aspects of the process that has been followed to now. So we're here to talk about that, to talk about the process leading to where we are now, the process that lies ahead, and also what AfriForum can do and other civil society organizations can do to combat expropriation without compensation. So with me today is Willie Spies from Hurter Spies Attorneys and also a lawyer for AfriForum, and also Advocate Mark Oppenheimer of the Johannesburg Bar. So Mark, I'll start with you. You wrote a legal opinion for AfriForum on the bill that was published in terms of changing the Constitution, and you of course made the comment that you believe just in terms of the content it would be unconstitutional. So why is it unconstitutional to change the Constitution?
So there are a couple of ways we can think about it. The first is, we must remember that that drafting committee was given a particular mandate. The public was surveyed to put in their opinions about whether they wanted it changed. 60% of people said that they didn't want it changed. And the committee then said, well, what we'll do is make explicit that which is implicit, which implies that you can't do any change of substance, but you can express why there might be certain cases which currently are allowed in the Constitution which allow for expropriation without compensation. But you have to take these 5 factors into account. So the first factor is the market value, and then there are 4 others that adjust the value up or down. So what the use of the land will be, how it was acquired, whether there was a state subsidy. So for example, we can imagine that the state provides someone with R1 million subsidy to acquire a piece of land. Its value remains R1 million, and the state then later expropriates it. They would then pay nothing because the 2 values cancel each other out. But this amendment goes well beyond that. So firstly, it's not just limited to land, which was what was in the public documents. It's land and improvements, which includes your house, a factory that you built, a business, a dam, crops. So a wide variety of things. There must be a fix to the land, so it's not your shares or your car. What it then does as well is, instead of saying, let's look at the 5 factors that are currently in the Constitution, it says these 5 factors will be determined by national legislation yet to be passed. So you have a bypassing of the Constitution, and this is where we can talk about something being an unconstitutional change to the Constitution. Section 2 of our Constitution says that the supreme law of the land is the Constitution itself. And what this amendment does is, instead of making the Constitution supreme, it makes national legislation supreme, makes the Constitution subservient. Why is this a problem? Well, it takes 2/3 of Parliament to change the Constitution. We've never changed the Bill of Rights before, ever. But national legislation you can change at a simple majority of 50+1. So it might be that the first draft that comes out looks constitutional. But once you've changed the Constitution, you've handed the ruling government enormous powers. And that's not necessarily the Ramaphosa government. We must think of the ramifications of this 10, 20, 40 years down the line, that those people will have the power to pass ever more draconian legislation. So that's the first reason why I think it's unconstitutional. The second one is in Section 36 of the Constitution, which is the limitations clause. Basically, the idea is that if you're going to limit any right in the Bill of Rights, you can only do it if it's justifiable in an open and democratic country. And we know through our case law that the one way to work that out is you look at, well, what does the international community do? What does international law say? International law says when you expropriate land, you must pay compensation that is prompt and adequate. At the moment, our constitutional test is just and equitable. But if you say that you pay no compensation, you are then doing something which flouts international law. And you'd be flouting Section 36 of the Constitution, because you'd be limiting a right in such a severe manner that it would no longer be in line with international standards.
Maybe to bring in here, Willie, there's also been this debate, or not just a debate, this court battle in terms of the process leading up to now. And I think a lot of people have forgotten about the court case that still has to be heard, that was, I think, filed in 2018, where AfriForum's concern was that there was a list of procedural irregularities in reaching the point where we've gotten to at that stage. So maybe just an update, what is that court case about, and how will it go forward from here?
Yes, Mark, we're just speaking about the mandate that was given to the committee. The mandate was actually given by a prior committee and then sanctioned by Parliament. And that committee conducted its work during 2018 And the idea was to gauge the view of society in order to decide whether or not it is necessary to change the Constitution or to grant this mandate to look at certain amendments in the Constitution. When that happened, submissions were made in 3 different ways. The one was through public meetings. Yourself attended many of those. The other one was through parliamentary oral submissions, where AfriForum was also quite vocal. And the third one was where members of the public, ordinary people, were able to make written submissions. Obviously, thousands, hundreds of thousands of people actually participated in this process. And Parliament was literally flooded with public comments made by ordinary members of public. What then happened was that instead of the committee exercising their constitutional duties to consider the submissions and then to develop their view based on the submissions that they have actually considered themselves, they appointed an independent contractor. And the independent contractor was tasked with the opportunity to categorize all the written submissions that were received and to count them as if they were ballot papers, and then to make a short abbreviated submission to the committee, which the committee then considered and based their views upon. Our approach from the outset was that this is unconstitutional. The Constitution is very clear that Parliament needs to engage public participation whenever public participation process is followed, and Parliament needs to consider, or if not Parliament as a whole, then the specific committee of Parliament delegated with the authority to do that should look at those submissions, consider them, and then make a proposal. It's exactly this that did not happen. We felt at the time, and that was during November 2018, that it may be appropriate to approach the court on an urgent basis and to apply for an interdict, to say, well, the rest of this process that will follow from the comedy proceedings should be interdicted. Unfortunately, the urgent proceedings did not succeed. The interdict was not granted, but the time frame was laid down, and as part of the time frame that was laid down for the disclosure of further information to us, because in review proceedings, the party applying for a judicial review has the right to gain insight into the record and all the documents that led to the decision that's been taken on review. As part of that disclosure or discovery process, we would have been granted the opportunity to gain access to what was before Parliament, what was the record of the proceedings, and then to supplement our papers. Unfortunately, those records were disclosed to us at a very, very late stage, only during the course of 2019. And subsequently to that, we supplemented our papers, and we are now waiting for Parliament to respond or to reply to our supplemented papers. But the matter is still very much alive. And what is of significance is the question, if we succeed with this application, and if it is found that the committee that actually did some work that led to the mandate to Parliament, and subsequently Parliament appointed a further committee based on what was given here, if it is found that this first step was unconstitutional or was done in an unconstitutional way, how would it affect the rest of the process? I think there's a strong legal argument that would say the entire process is then flawed, and the entire process should start over again. And with that being said, I think the application that is pending at the moment is still very relevant, it's still very important, and we are looking forward to see the answering papers of Parliament in our application, and we are looking forward as well to have the matter enrolled in court and heard and argued, because we believe that it is a clear constitutional principle that needs to be tested, that needs to be applied, and needs to be given clarity on.
Well, it can make you wonder whether the argument on that it was urgent, whether that was not the right approach, because if the process has gone that far, surely it would have been better to say, let's deal with this issue before we continue with the process. So do you think, in terms of considering politics and realities outside of the courtroom, that the fact that the process has continued to such an extent would be detrimental to this case, that a court might feel maybe on the merits of the argument you are right, but it would be too detrimental to the whole process to say that we grant in your favor.
Yes, that relates to the whole question of mootness of a certain matter. But the interesting thing is that mootness is irrelevant where it has to do with the unconstitutionality of an action. If an organ of state acts unconstitutionally, mootness can never be a justification for that or a way to escape the interference of courts. Our Constitution actually grants the judiciary with a mandate to ensure that actions that are taken are constitutional. And even if there has been many developments since whenever the matter was instituted first, the fact that the breached have or the water has passed can never be an argument to justify unconstitutional conduct. It will still remain a prerogative of courts to declare the conduct unconstitutional if we succeed, and the consequences that will follow from that will still be the same, arguably.
I want to add to the discussion, Mark, there was, other than the bill that was published, there was also I guess you can call it a policy document that was published in terms of who would be the beneficiaries of expropriation, of land reform, and in this sense. You also wrote an opinion on that, and you were quite alarmed by the way this approach was formulated. Why do you think the issue about who would the beneficiaries be is a problem?
The policy identifies two different kinds of beneficiaries. So the first is people that are poor and vulnerable. And I think there's something in that to say that, those that don't have and have the skills to work on farmland. It sort of specifically looks at farmland. But the second category is done on the basis of race. As South Africans, we come from a history of racial exclusion and of racial categorization. And if we accept that racialism really was the source of a lot of our problems, then we must also accept that it cannot be part of our solutions. So what the policy does is specifically exclude certain racial groups from benefit. It also then necessarily requires a classification system to work out who will be a beneficiary, who counts as black, who counts as coloured, who counts as white. Now, in 1950, we had the Population Registration Act, which classified people through classification boards, and people were put through humiliating procedures, and the state would determine, what colour they were, what race they were. There were a number of different subgroups that were largely sort of fabricated by the state. So to give you an example, one way to work out if you were Indian was if you cohabited with an Indian woman and you were a white man. That made you an Indian. People would look at the texture of your hair. They would ask who your friends were. All sorts of strange things that sort of seem completely disconnected from any scientific view. This kind of racial classification, which also sort of tell people who they could marry, where they could live, eventually we disbanded that system. And so we no longer have any legislative framework which tells you what race you belong to. So the idea that you would then have a policy which allocates burdens and benefits on the basis of race without having any mechanism to determine who counts, well, that seems absurd on its face. What seems more pernicious is then if you reintroduce such a system, so that you say, you get this piece of land because we think that you have enough of the preferred racial blood in you that will give you this access to this land, or we think that you're too pale, so sorry, you don't get the land. That really should remind us of the dark days of apartheid, and not the kind of thing that we want to do ever again. So it is rather chilling that this policy contains such a race-based system for allocation.
Then more recently there was this announcement by the ANC's executive committee that they in a way went against the bill that was published and said that you made the point now that the bill sort of says that the power should be taken from the Constitution and given to Parliament, and now we heard the leadership of the ANC say no, that's not what they want. They want the power to be given to the executive. Why is that a problem? Because I've seen commentators saying, well, it's not really a problem, because remember, and the ANC's argument is it's a democratically elected government, so what's the problem with giving a democratically elected government the authority to decide on how this should be dealt with?
Yes, so if we look at the way the Constitution is currently drafted, Section 25 says that after looking at those 5 factors we've discussed, a court can determine what your amount of compensation is. And so if we think about how that'll work in practice, what you might have is the executive will say, we're expropriating this piece of land, and they will provide some evidence as to what that land is worth, maybe a valuer general, And the person who is the current owner will then provide their own evidence as to the market value and the other factors. And then the court will weigh that evidence up and determine what the price should be. Now, courts are well trained in this. They do it in all sorts of civil litigation. So if you've got to work out, if someone's lost a leg, what's the fair amount of money that they should be compensated, or if there's a contractual dispute, this is the bread and butter of courts, to determine quantum. What the ANC are proposing is a radical departure, which is to remove the court's power to do that in the first instance. To say that the executive not only will determine which land will be taken, but they will determine price, and that price can be zero. Now what you then have is this concentration of power in the hands of a very small number, who may use that power for pernicious reasons. When we think of the executive, we might think of our current president and the cabinet, but it may also refer to the mayor of a small town, who may decide that, well, the way to enrich himself or to settle scores is to take people that live in that town's land and to pay them nothing. And then the courts will then have a very limited power under review. So after the state has come in and confiscated your property, you could then approach a court and say, well, this was a violation of my rights. But instead of being able to adjudicate it from the beginning, a court can only use review powers, which are limited. Really, it's a rationality test, not a proportionality test. So a court might say, look, the amount that you've been paid is completely disproportionate to the value, but it is not totally irrational, and therefore I'm going to confirm it. You also then place this huge financial burden on the person who's just had their vital asset confiscated from them to now pay as an applicant to go to court. So it's a draconian thing, and the idea that it's democratic, well, this is to obfuscate what is meant by democracy. Democracy is not just majoritarianism. It's not just what most people want. We have a constitution which places certain limitations. So, for example, it may be the case that if you ask most South Africans, should we have the death penalty, they would say yes. But we have a constitutional right to life, and our constitutional court has said that that right to life means that you do not execute people, regardless of what the populace thinks. So to sort of slide into this idea that it's democratic because the executive represents the will of the people really is to align what democracy requires, which is checks and balances, distributions of power, and the protection of fundamental rights like the right to property.
In your video, you also made a comment about the fact that we've had quarter of a century of reparations and restitution so far. Maybe if you could just briefly elaborate on that.
Yeah, I think that's an important thing to point out, that there is a feeling that we need to do this because we need to right the wrongs of the past. And I think what we need to first acknowledge is we have to do that. That is right. In other words, if people were dispossessed, justice requires that they are put back in the position they would have been in had the wrong not occurred. But then we must say, well, what has been done? And between 1995 and 2014, we had a land claims process where those that had land taken from them between basically any time after 1913, so during the colonial era and the apartheid era, could put in a claim. And we know that 95% of the claims that were brought during this process have been resolved. 1.8 million individuals receive compensation either in the form of land or money. What's interesting about this is that when given the choice between land and money, 92% of people said they prefer the money. Now, part of that is because money is freedom. Money is the ability to pay for your debts, start a business, or buy a piece of land where you choose, as opposed to an ancestral piece of land. But for those where that particular piece of land would have had a significance, they were given the option and they could have kept it. It's important to recognize what good has been done with regards to restitution of land, and we should celebrate that fact. But then it should not be used as a false vehicle for encouraging mass redistribution under situations where we have really done the right thing over the last 25 years.
Valiso, what's the way forward? We spoke about the way forward in changing the constitution, but what's the way forward from AfriForum's perspective or from a legal perspective in terms of fighting this in the courts?
Well, we've spoken about the pending court case, which is still pending and which will proceed. I understand that there are also a whole range of other organizations also considering to start new court actions, new court applications, and I believe that at a certain stage in future all these court applications would flow into one consolidated kind of matter that will end up before the Constitutional Court. So it is our matter. I understand that the Institute for Race Relations is in an advanced stage of preparing papers for a separate court battle from their side. The Helen Suzman Foundation gave indications that they interested. The political parties, obviously, the Democratic Alliance, the Freedom Front Plus. There's a whole range of organizations, each coming from a different point of departure, but to a very large extent agreeing on this principle of the importance of maintaining the protection of property. Somewhere in future, and I believe it will probably be not this year but next year probably, these applications will end up before courts. They will start off up in the high courts, I believe, and they will end up in the Constitutional Court, most likely. The normal time frame for litigation that starts off in a high court and ends up in the Constitutional Court is normally minimum 2 years, maximum 3 to 5 years even. So depending on how this matter is going to be dealt with by the litigators, I foresee that for a substantial amount of time this matter will still be before the courts. There is a possibility that it could be fast-tracked and that the Constitutional Court could at a certain stage decide that it's in the public interest that this matter has been dealt with expediently in some or other way. That could speed up the process, but the expectation is that we are in for a long legal battle from different points of view, and eventually, hopefully, we end up with a situation where reason will prevail. Let's see if it happens. I really believe it is still possible.
Willie Spies and Mark Oppenheimer, thank you very much for coming in and sharing some information. I'm sure, I think from AfriForum's side at least, we are more than eager and willing to take on this issue. Thank you.
Absolute pleasure.
Thank you.